SJC-13466, Commonwealth v. Armani M. Huacon, and SJC-13466 in the matter of a juvenile.
Okay, Attorney Faulkner, whenever you get settled.
May it please the court. My name is Benjamin Faulkner, and I represent Armani Huacon. With me is trial counsel, attorney Andrew Zyberg. In this case, this is a reported case from the juvenile court regarding whether somebody who has been found not competent as a result of a non-mental illness can be forced to undergo treatment in order to be remediated or restored to competency, although, as pointed out in the amicus brief, remediated, I think, is the appropriate term to use here because he wasn't necessarily ever competent in the first place. Now, the statutory scheme that governs how the courts address competency concerns was enacted in 1986. And it was enacted, the entire Department of Mental Health Code under the entire Mental Health Code and what was then the code entitled Department of Mental Retardation, which has now been renamed to the Department of Developmental Disabilities. Both of those codes were enacted at the same time together in one act. And what's significant about those being enacted together is that all of the competency issues were lumped into the Department of Mental Health Code. And the Department of Mental Health Code provided both for how the court determines whether somebody's competent to stand trial, but also what happens after somebody has been found not competent to stand trial. And in particular here, what the legislature did was it enacted a series of treatments that may be provided to somebody who's not competent by reason of a mental illness. That person can be committed either to Bridgewater State Hospital or to the Department of Mental Health for a period of 6 months. That person can be ordered to undergo involuntary treatment, provided that they meet the criteria for commitment. But there's no such provisions under the code that determines, that governs the Department of Developmental Disabilities. There's no ability to involuntarily commit somebody who meets the definitions under the Department of Developmental Disabilities. There is no involuntary treatment of any kind that's provided for people that fall under the code of the Department of Developmental Disabilities.
Counsel, I don't mean to cut you off, but this is 1986, right? And we certainly, it's an entirely different world with our understanding of the interplay with developmental disabilities and understanding that it's not a mental health issue. This just wasn't the world. So I think what we're talking about here really is we can agree that it's not in the statute, but now when we talk about where we are in the juvenile department, where you have children with developmental disabilities, and now it's impacting their ability to assist their counsel as they go forward with their defense. Why doesn't this make sense that a juvenile court judge should have the inherent authority to order what would otherwise be ordered if we're talking about a mental health diagnosis?
Well, first of all, I would begin with Commonwealth versus Norman, which is that pretrial orders directed at either a juvenile or an adult have to be authorized by a statute. And while Commonwealth versus Norman goes to bail conditions, here we have Section 58A that also authorizes conditions of release. But those conditions of release are to be ordered with an eye toward the protection of the community. What the Commonwealth is seeking here is for the juvenile court judge to be able to order the juvenile to undergo treatment, which essentially advances the Commonwealth's interest in prosecution, but is not geared toward protecting the safety of the community and is not geared toward the best interest of the juvenile. Now, while it may be...
But what happens when the juvenile doesn't receive this treatment? What's the remedy?
When the juvenile does not receive the treatment?
So it does not become competent to stand trial?
So a juvenile that's not competent to stand trial, the statutes do address that. The case is stayed until such time as somebody is competent to stand trial. The case cannot proceed. And under certain circumstances, which is the companion case, the juvenile can seek dismissal of the charges so long as the interests of justice are met or other conditions are met, which are being dealt with in that case.
But you would have a longer road to hoe because your case is a YO, right?
Potentially.
Because of parole eligibility in that Section D portion, right? Dismissal.
Right. In terms of dismissal, and I think really
But either way, you're here to argue you can't remediate. And if they're not competent, then whatever happens down the road.
Right, right. Because the way that this case comes before the court, this is not before the court on a motion to dismiss, as the other case is. This is at the stage where the Commonwealth is seeking to order the juvenile into treatment. And I think the important thing here is there are many states that have set up programs. And these programs involve the kind of fact-finding that legislatures do. How do we address these cases so that everybody is treated equally? So that a whole class of persons, we know what to do with them. What the Commonwealth wants here is this unique ad hoc expert to come in just to teach this person how to become competent, essentially. And that's not the kind of process that a juvenile court should be doing. It shouldn't be designing a new competency remediation program for each individual that comes along. That's the role of the legislature. That's the role of the Department of...
But a court, we have inherent powers to run the judicial system. If we can't, this case just sits in limbo and goes nowhere. I'm not sure that's good for your client either, because your client can't prove that he didn't do it or that he shouldn't be in this process either. You know, he's just, a big cloud hangs over his head as well, right?
Well, there is a remedy. Commonwealth versus Hatch allows for somebody that has been found not competent, who's got evidence that they're not guilty or not delinquent or not a youthful offender, can demand a hearing and can require the Commonwealth to present its evidence. So there are other remedies that are out there.
What about the court's power to, get its cases done?
Well, the court, again, I think I would go back to the fact that while the court may have certain inherent powers, what it doesn't have is inherent powers to order defendants to meet certain conditions. And again, that goes back to Commonwealth versus Norman, which is a due process right. But more importantly, when we look at, I think it's...
The court has certain powers to, determine whether a defendant or a juvenile is competent. The question is, does it have this additional power to provide services that will help facilitate rendering the juvenile competent, right?
Right, but this court has already found that somebody who suffers from an intellectual disability cannot be committed involuntarily. That those statutory provisions only apply to somebody who is mentally ill. And again, this is an area where the legislature has legislated.
But this isn't necessarily what we're saying, because the order could be outpatient. It's not saying we have to civilly commit the child, but that the child would, and there was some, I believe it was the guardian ad litem, in certain things that could be pursued.
Right, so the guardian ad litem did produce a report which suggested that if certain actions were taken, that the juvenile in this case may attain competency. The juvenile court didn't accept those findings necessarily, it simply restated that those things may assist him, but that's different from by a preponderance of evidence that they would, first of all.
No, I was raising that with respect to your point that we would be committing the juvenile. I'm only making the point that it could be in the community, outpatient.
Understood, and I guess my only response to that is that commitment is the only process by which the legislature has provided that somebody can be treated, and when the legislature does legislate in a particular area, here treatment, it would be inappropriate to use the court's inherent powers to do something that the legislature didn't provide for when the legislature did in fact enact a comprehensive scheme, which by the way has been repeatedly amended since 1986. So even though the original acts are old, the legislature has continued to address this. And I would just, if there are no further questions, I would just suggest that this really is a problem that is best to be solved by the legislature.
Okay, thank you very much.
Thank you.
All right, Attorney Freitas.
Good morning. May it please the court. Debbie Freitas on behalf of the Youth Appellant. With me is Christina Freitas, Appellate Co-Counsel. The juvenile court cannot order competency remediation because its role is to shield cognitively limited, incompetent youth from being tried in absentia. And as Attorney Faulkner argued, it's not within the court's inherent authority to order it. Rather, to the extent that there is a gap here, it is for the legislature to fill. Further, the Commonwealth failed to meet any burden of proof regarding the youth's ability to attain competency after he was again found incompetent. And the juvenile court erred in not holding the Commonwealth to any burden and by not dismissing the case, given that the youth is unlikely to attain competency in the foreseeable future. The Commonwealth must carry the burden of proof regarding a youth's ability to attain competency. And as the docket sheets reflect in this youth's case, the court is already called upon to make two findings at every competency hearing. The first is whether the youth is competent, and the second is if the youth is not competent, whether the youth will become competent in the foreseeable future. Due process and fairness require the Commonwealth to carry the burden for both of those. As to the first inquiry that happens at a competency hearing—
Where's the source of the second one? The second requirement you come up with, that they have to do that at that time? Because it's a little hard when they can't decide whether he or she is competent at that time, and you're saying they can't do anything about it as well. So you're adding a third component out of where?
So I'll point the court to the docket sheets that already provide for those two findings. I believe in the record appendix, volume 1, pages 20 and 35 have those findings made. For example, the court makes them multiple times because—
No, but where's the legal authority? You're saying there's a second component that the Commonwealth has to prove after each incompetency proceeding that the juvenile could become competent. You're kind of, I don't know what the basis for that is, and because your first argument says they can't do anything about helping make the child competent, it seems a bit unfair to impose the second requirement too.
Yes, Your Honor. So I believe the language that would be important to the court is found in Calvaire and repeated in Sheriff.
That's for dismissal.
Yes, it is for
Right, I
dismissal.
think to clarify, that's for dismissal on the 16F, right?
Right.
Yes, that is the language used for a dismissal, which I think is relevant because if the
And
court—
there's a time component to it and a due process component to dismissal.
Yes, for incompetent adults, there are two methods by which to attain dismissal under 16F. The first one is mandated. It is a time certain, independent of any other factors such as current safety to the community. And the second is more of a due process, interest of justice. I think it's important because for a youth that's found incompetent and not able to attain competency in the foreseeable future, there is no trial in sight for that youth. And so the Commonwealth's compelling interest to prosecute is not so compelling in that circumstance that it trumps a youth's interest in liberty.
Counsel, could I just ask you, even though I know we're talking about the juvenile court, does the Commonwealth have that burden in adult cases?
I believe the Commonwealth has that burden in all cases.
Are you aware of any case where if the defendant were found to be incompetent and the time just continues to tick for either halftime or 16F purposes, that every time the Commonwealth, we come back and there's an order of incompetency, that the Commonwealth then has a burden to demonstrate that the defendant could be returned to competency?
Well, if we were to move forward from a first competency hearing where the youth is found not competent, in order to have a second competency hearing, the Commonwealth would have to show the youth would be competent at that hearing to proceed to trial.
And that's beyond a reasonable doubt, the Commonwealth's burden.
At the trial, yes. But even at a second competency hearing, it would be on the Commonwealth to show that that youth is competent by a preponderance of the evidence. In order to have that second competency hearing, shouldn't the Commonwealth have to show that we should even have a second competency hearing? If the youth has a slim chance of being remediated or restored to attain competency in the foreseeable future, there is no trial in sight. The purpose for a continuation is to see if the youth will be remediated. And so in this case, we'll deal with someone who...
Maybe that pushes towards the opposite answer on your first question, that maybe the Commonwealth and the courts do have the capacity to order, services to help make the juvenile competent, because then we could answer both questions.
So, Your Honor, respectfully, I think this court has already taken up that issue in Commonwealth v. Kendrew. So in that case, a criminal defendant comes into the district court and is ordered to be observed and examined at a secure facility. And the forensic provider at that secure facility comes back and reports to the court that due to mild, what they said at the time, mental retardation and other disorders, this person does not suffer from a mental illness but may be harm to themselves or others. But because the mental illness component is missing, they cannot be housed in this secure facility. And as a result, the district court judge thereafter provides custody of Ms. Kendrew to the Department of Mental Retardation for the purposes of placement. Placement is a service. And the Department of Mental Retardation appeals. And this court finds that, in fact, Ms. Kendrew's incompetence due to her cognitive limitations does not result in this court or any court requiring inherent authority, because her inability to be tried because of incompetence does not impede the court's essential functions. And in that case, the court even notes that there may very well be a gap, a legislative gap in what we do with cognitively limited defendants, but that gap is for the legislature to fill, not for the court. And 29 years later, the legislature has not acted. And in fact, we are in the same statutory scheme, essentially, that we were when Kendrew was decided. And so really, there's no more interest in finding or concocting inherent authority here than there was there. And so where the youth is the one who has a liberty interest, it's important that the government be the one to carry the burden on any issues related to competency. And I'm not sure there's any context in which someone with the liberty interest would carry a burden. More importantly, it's the government's interest to continue the prosecution. And shouldn't it be on the government then to have to prove that a prosecution is
As long as
possible?
there's an existent cognitive limitation, albeit an adult or a juvenile, the government is really under the gun because there's no way to prove they're going to be remediated, a potential to be restored to competency, right?
I respectfully, I disagree. I think every competency hearing does have experts who do provide information on whether a youth could attain competency in the foreseeable future. As to cognitively limited
Well,
youth, so the
skip to
record
that's the harder
here,
part, right.
yeah, so the record here, the experts did provide testimony that the type of deficits that the youth suffered from are not amendable to change. However, there are many other contexts in the juvenile court and also in the adult court.
But what you're saying is it has to be amenable to change organically. It can't be through
It shouldn't be through,
through any type of remediation or teaching.
yes.
At least not ones provided by the court.
Yes.
If the legislature stepped up, as other states have, then obviously those would be available.
Yes, Your Honor, precisely.
Do you cite the Kendrew, that case in your brief?
Yes, it's in the reply brief.
Okay, thank you.
Thank you very much. I will rest on my brief.
Okay, Attorney Huacon.
Good morning. May it please the court, Kristen Jang for the Commonwealth. In the absence of a formal competency remediation program in the Commonwealth, the court has the inherent authority to appoint a remediation counselor or educator and to compel the juvenile to participate.
How is this any different from adults? Because I've seen it in Superior Court in adults who have cognitive limitations, organic brain disorders, et cetera, and it's a gap when they don't have a defined mental illness. But in those situations, you take the defendant as you see it, and it's to the detriment sometimes in violent cases to the Commonwealth. But as I've seen those cases play out, there's nothing really the court can do. Why is this different?
The juvenile context is different because I cited some of the research in my brief explaining the difference in the juvenile context, because a lot of times these juveniles have a complex web of issues, some of which may be remediative, some of which maybe
Right,
not.
that goes to treatment, but this
Yes.
has to do with the court's authority, where we don't have that authority, as I saw it, in adult cases. That just has to do with whether it's capable of remediation versus the court's authority, as Justice Wendland pointed out, as opposed to a legislative program.
Sure, and I suppose in the right case, if this court finds that the juvenile court has the inherent authority, I don't see why in the correct case in the adult context they wouldn't have that authority as well. It's just in the juvenile context these issues come up so much more often. That's why it's heightened in this context.
But then how do we operate in this ad hoc fashion, that we're going to appoint experts, we're going to come up with curriculum, we're going to hire special education teachers to do this?
Yes, but
Like a legislative function to
if
me.
the legislature were to pass a statute similar to these other states, and I believe the amicus cited a bill that's pending before the legislature right now. I took a look at it, and it wouldn't be a whole lot different, to be quite honest, than giving.
But I think Justice Gaziano's point is that we as an institution are good at trying cases.
Yes.
We're not good at setting up programs to remediate youth.
Agreed, but also
But so doesn't that suggest an institutional limitation on our power to craft such programs?
I don't think
In
it
fact,
has.
wouldn't there be a due process problem maybe if we did and it didn't work out and there was some harm to the child?
Well, I'm having trouble picturing what the possible harm could be to the child, because at the end of the day, we still would have to have a competency evaluation again to decide whether or not they're competent. So the worst that could happen is that they still are not competent.
Well, there's a little bit more than that, because listening to Attorney Faulkner and Attorney Freitas, the other harm is they are restored to competency, and then the proceedings proceed. And they're either found delinquent or they're found as youthful offenders, and they're doing that by the conduit of the court ordering them to these remediation services.
But the
I
problem,
mean, isn't that a problem?
the problem is right now they're being harmed by these cases just sitting there languishing. And
I think they're more than happy to have them languish, as opposed to being tried for armed robbery, at least in the first case.
well, at the same time, the juvenile court is designed with a rehabilitative purpose, and they can't access any of those benefits with the case just sitting there. The court can't do anything at this point.
The benefit is that at the end of the day, the case gets dismissed.
Well, but at the same time, the court has.
I understand there's a substantial harm to the Commonwealth in that you have victims, you have people who may have been violently attacked by a juvenile who has a situation. I get why you're pressing this, and I understand there's a significant, potentially significant harm to the Commonwealth, but this kind of exists in a gray area at this legislative point in time.
Understood. Understood, but assuming that the legislature does pass some sort of statute similar to what's been proposed, it just says the court has the authority to appoint a similar specialist. It gives some time frames, but I'm not sure that it would be much different than now.
The difference is that the legislature does it, not us.
Well, the legislature just says the court has the authority, put some time frames in, but.
I mean, the legislature can pass the statute and put in whatever they deem necessary and proper.
Correct, but if you take a look at the proposal currently, it would simply give the court the explicit authority.
Which allows us to do what you're asking us to do.
Correct. Puts in some time frames, but it doesn't necessarily set up the infrastructure that I think is what my brother and sister are calling for.
I think the point of the pending provision is perhaps that in the absence of such a passage of a proposed statute, we don't have the authority to craft on our own a program.
But at the same time, we have a lot of testimony here on the record about these particular deficits in these two cases. And we even had a GAL appointed that did a little bit of research and investigation into what maybe would help one of the particular juveniles. So I think we have a lot of information about what would help in these particular cases.
What may help, right?
It may, and then that's in every single case.
But that
we
goes
don't
to
know.
the efficacy of
Correct.
the efforts as opposed to the authorization for the
Correct.
efforts.
That's exactly right. And then, after a certain period of time, and the court can.
So given that the statute is really sort of a comprehensive statute that leaves this gap open, and given that there's a pending legislation to fill the gap, what's your best argument that we currently have the authority to put these programs forward?
Because my best argument is that this goes to the essential functioning of the court. These cases cannot proceed unless we're given the opportunity to potentially remediate these juveniles.
Well, okay, assume the premise that we can't do this. I'm
Yes.
really interested in what do we do in this world? Because as Justice Gaziano mentioned, this happens in the adult docket all the time. Sure. But in the adult dockets, we have 16F and we have other mechanisms to deal with it when it starts to languish. But if you could first, when the incompetency reports come back, can you talk about whether or not the Commonwealth should have a burden on the return of a juvenile who's been deemed incompetent, and now they're off, and now we go back and set another date to return to see whether or not things have changed. Should the Commonwealth have a burden of demonstrating that there's some reasonable expectation of being returned to competency?
Under due process, I don't believe that just the pendency of the charges alone would require the Commonwealth to have to show that.
Well, didn't the Supreme Court already tell us that they do? I mean, isn't that what the Jackson case says? And we repeated it in Abbott A. There has to be, under due process, an expectation that sometime in the foreseeable future, a return to competency will happen. There has to be showing by the Commonwealth of progress towards that goal. I mean, those are constitutional requirements.
Correct. I completely agree with that, Your Honor, but I would distinguish those two cases in that the deprivation of liberty was much stronger in those cases. In Jackson, the defendant was held under a civil commitment just for purposes of the criminal case, not because his health and safety was at risk. He didn't fall under the mental health statute. And then under Abbott A, that was dealing with a situation where the juvenile was being held for dangerousness.
And I'm sorry, what are the facts of these two cases?
These two cases, one of them, the first case, the juvenile was held for dangerousness but was released after an Abbott A type of hearing. He's now been held again, just
Okay.
because he violated
So
conditions.
the first juvenile is being held. What's the second
The
one?
other one, he is out on conditions.
Okay, thank you.
So I would submit that the case law does not support, just based on the pendency of criminal charges, that that due process requires the Commonwealth to show remediability at every single competency hearing. And I would submit that in the juvenile context, these cases can be very complicated because a lot of these juveniles have a number of issues, whether it be a combination of cognitive disabilities, mental health issues, family stability. So it might take a while to even determine whether it's possible to remediate these juveniles. So I think I would caution the court against imposing time limitations that are too short, that would require, even at the competency stage, determining whether a juvenile is competent to make predictions at too soon in the process. And I do want to discuss the case DMH v. Kendry, which my sister cited. I do want to distinguish that case because in that case, the court found that the court lacked the inherent authority to order DDS to provide services to the defendant in that case. So that case had more to do with the court basically telling an executive agency what to do. That's not what I'm proposing in this case. I'm not saying that the court has the inherent authority to force DMH or DDS to really do anything. And in that case, it seemed to me that the criminal case was pretty much wrapped up at the point when that order was made. In these cases, the criminal case cannot proceed unless and until something happens with these kids.
How would this case be different? Because a lot of the times you have the same issues that you have on the adult dockets, where a lot of these juveniles don't have any money and they're indigent. And so to the extent that the court would order services, they would likely be DPH services, and you would have an Article 30 issue. Where would the court order the services to be given to the juvenile but for state agencies?
It would have to be perhaps even a private individual that would come in and do this, charged by the hour or something like that. This would have to be a pretty specialized person, as you can kind of see in other states, what sort of backgrounds are required of people that do this. It would have to be a pretty specialized person, but the GAL, at least in the first case, provided some resources where we can look to try to find these people. I know this is not part of the record, but I spoke to some experts in this area, and one of them told me that the ideal person in her mind would be a retired special ed teacher that just has the time and the patience and the background to perform this type of work. So I believe these people could be found, and I don't believe we need to kind of reach out to DMH and force them to do something that's not within their mandate.
Okay.
If there are no further questions, I'm happy to rest on my brief.